Hello everyone, we've made it to our kind of final lecture here about the criminal trial process and kind of the court system overall. So without further ado, we're moving kind of into the heart of the trial process. So in the last videos we talked about what happens from the time you're arrested through those initial phases, whether you plead out at your arraignment and plead guilty, or plead not guilty, right, and the plea bargaining process, all of that stuff. So now we've come to the point where they pled not guilty and they didn't take a plea agreement, and we made it to trial. So the trial overall can kind of be broken down into like 4 major steps. So first we have our opening statements. So these are like a roadmap for the jury. The prosecution goes first in criminal cases, laying out their theory of the case and what they intend to prove. In the opening statements, they're not providing any evidence. They're just kind of promises of what the attorneys expect the evidence will show. So they're not delivering any evidence during the opening statements. The defense can choose to give their opening statement immediately after the prosecution, or they can reserve it until after the prosecution's case in chief is complete. So after they've presented their evidence and everything. So then after the opening statements, we move on to our evidence presentation. So this is kind of where the real work happens. The prosecution presents their case in chief first, calling witnesses and introducing physical evidence. Each witness can be cross-examined by the defense. At this point, it's crucial that you guys understand that this is adversarial in nature. So the defense's job is to challenge every piece of evidence through cross-examination. After the prosecution rests, the defense may present their own case, though they're not required to do so. So they could simply just cross-examine everything and not present anything new of their own, or they can potentially cross-examine the evidence that's presented by the prosecution and then still present like an alternative explanation or introduce other witnesses or things like that, right? After this is all done and both sides have had their turn, we get our closing arguments. So this is the attorney's final chance to persuade the jury. And unlike the opening statements, attorneys can now argue about what the evidence means and why the jury should interpret it in their client's favor, with the prosecutor's client being the state and the defense attorney's client being the accused or the defendant. The prosecution gets 2 opportunities, so they go first, then the defense responds, and then the prosecution is able to have like a rebuttal. And this is because the prosecution does bear the burden of proof. Before they proceed to our jury deliberations, the judge then gives instructions to the jurors. So they instruct the jury on all of the applicable law for this case, and this includes defining elements of the crime that is been charged, and then explaining the burden of proof and providing guidance on how to evaluate the evidence. Speaking of evidence, it is the foundation of any trial. So we have the types of evidence and all of the kind of requirements around those types of evidence. All of that is important to understand, so we'll kind of walk through it systematically. So first is witness testimony. This is what people say under oath. The witness must have personal knowledge of what they are testifying about. They can't just repeat what someone else told them. That would be hearsay, and hearsay is not admissible in court as evidence. Expert witnesses are different. They can give opinions with their area of expertise. So they don't have to speak about or testify about what they saw or what knowledge they have of the crime. They can just provide their professional opinion based on whatever their area of expertise is. Then we move on to physical evidence. So these are tangible items. So the key legal concept here is the chain of custody. The prosecution must show that the evidence hasn't been tampered with from the time it was collected until it's presented in court, and every person who handled it must be accounted for. Moving on to our documentary evidence. These are any written materials like contracts, medical records, or business documents, and they have to be authenticated, and someone has to testify that the document is what it says it is or what it purports to be for it to be used in court. We have circumstantial evidence, so this is indirect evidence that requires the jury to make logical inferences. So, for example, if someone is found with wet clothes and an umbrella, you would maybe infer that it's raining, even though no one testified about the weather. Contrary to popular belief, circumstantial evidence can be just as powerful as direct evidence. Character evidence can be used. It has very limited admissibility in criminal trials. Generally, you can't introduce evidence that someone has a bad character to prove that they committed a crime. So you can't just get on the stand and talk about how bad of a person the defendant is to try to convict them of the crime, right? However, there are exceptions, such as like when the defendant kind of opens the door by introducing character evidence about themselves. So if the defendant gets on the stand and they speak about themselves, or if there are other character witnesses that are testifying on behalf of the defendant, that does open the door for the prosecution to then kind of cross-examine those folks and use whatever they get out of that cross-examination in their favor. So remember in criminal cases that the prosecution is responsible for proving guilt beyond a reasonable doubt. And this is the highest standard in our legal system, right? So all of the jurors need to be convinced that the accused is guilty beyond a reasonable doubt. So we kind of move then on to our jury deliberations. So after the judge gives their final instructions, the jury's work can really begin. As we begin this process, the jury is escorted to a private deliberation room where they can speak freely for the first time about the case. The first order of business is usually going to be selecting a foreperson, and that person is going to lead the discussions and communicate with the court. Again, this is the first time that these people are allowed to talk about the case with anybody. Up until this point, they've been passive observers, and they've been instructed not to discuss the case with other jurors or anybody else, for that matter. They can engage in evidence review at this point during their deliberation process. So part of that allows them to request to see any of the exhibits that were admitted into evidence during the trial. They can also ask to have portions of testimony read back to them. Some jurisdictions allow jurors to take notes during the trial, so they can then refer back to those during deliberations. The key here is that jurors must base their decision solely on evidence that was presented in the court and the judge's instructions on the law, right? They can't bring in their kind of outside views or all these potential what ifs outside of what was presented directly to them. In criminal cases, the verdict must typically be unanimous, and if they can't reach a unanimous decision, it results in a hung jury, and the case must be retried with, another attempt at trying to get a verdict. Once they reach a verdict, the foreperson signs the verdict form and notifies the bailiff. The judge then reconvenes court with all parties present. And it's, important to note that deliberation times can vary dramatically. So a jury could deliberate anywhere from a few hours to several days, or even weeks in complex cases. And there's no real correlation between how long they deliberate for and whether someone is found guilty or not guilty. Once they've delivered their opinion, that kind of marks the end of our trial, or their verdict, I guess. But the trial's end is not necessarily where the case ends, right? So what happens next depends entirely on the verdict, and there are important procedural steps that you all ought to understand. So in the event that we get a guilty verdict, several things happen. So first, a sentencing hearing is scheduled. This usually occurs weeks or months later to allow for preparation for the sentencing hearing. The court may order a pre-sentence investigation report, which provides background information about the defendant to help guide sentencing. Victims may also be allowed to give impact statements describing how the crime affected them. If a not guilty verdict is reached, this kind of triggers those immediate consequences where the defendant must be released from custody immediately if they were detained, and the case is dismissed and cannot be retried. And this is a protection of double jeopardy that is found in the Fifth Amendment. It's important that you understand that this protection only applies after a jury has returned a verdict or the judge has entered a judgment of acquittal in criminal cases. So they can't be tried again on the criminal side. Now, if I deliver, or if a jury delivers a not guilty verdict for a crime, someone could then sue the person or bring a civil case against the person. So if it was like a manslaughter case that ultimately the person was found not guilty, then the victims or victims' families would still have the opportunity to sue the person for like wrongful death or something like that, for like damages. So the double jeopardy protection doesn't extend from like criminal cases to civil cases. It only protects you from being retried for criminal cases after you've already been found not guilty or acquitted. Then we have our post-trial motion. So even after a guilty verdict, the defense does have some options. They can file a motion for judgment of acquittal. So just being like, hey, this is wild. No reasonable jury could have found guilt based on the evidence that was presented. So they can just be like, hey, judge, actually, can you take a look at this and maybe overrule what the jury decided? They can also file for a new trial based on any errors that occurred during the proceedings. If that is not what happens, we move on to the appeals process. So this is a critical safeguard in our system. Defendants have the right to appeal their conviction to a higher court, but there are some strict deadlines. Usually it's about 30 days in most jurisdictions if you're going to start appeals. Appeals courts don't retry the case. They review whether legal errors occurred that affected the outcome. It's important for you all to know that the appeals process can take years and it involves complex legal briefs rather than witness testimony. It's ultimately the appellate court's job to ensure that the defendant received a fair trial under the law. So they're just reviewing what took place and deciding whether or not this person's rights were potentially violated, or if they were unjustly convicted of this whatever crime it is. Okay, and that is all that we have for this video, and that wraps up our kind of courts related content. I will see you all back for when we get into our next unit.